This is Bloomberg Law with June Grasso from Bloomberg Radio.
The Chief Justice has stepped into the Trump administration's escalating battle against the judiciary. This morning, President Donald Trump called for the impeachment of the judge who ruled against his deportation of alleged Venezuelan gang members to El Salvador, calling him on Truth Social a radical left lunatic of a judge, a troublemaker, and an agitator. And before noon, Chief Justice John Roberts made a rare public statement against Trump's impeachment call, saying, quote, "For more than 2 centuries, it has been established that impeachment is not an appropriate response to disagreement concerning a judicial decision. The normal appellate review process exists for that purpose." Joining me is an expert in the federal judiciary, Carl Tobias, a professor at the University of Richmond Law School. It's rare for Roberts to make a comment like this. How surprising is it?
Well, we had an inkling of that before. Remember, in his year-end report, he sounded a bit of an alarm, just saying he was worried about threats to judges, and a number of judges have spoken out. And so this is just a follow-on to that when he saw the severe criticism of Judge Boasberg in the D.C. District Court by President Trump today on social media. And I think he was concerned. And so I just think he is trying to calm the waters a little bit and say it's not appropriate to attack the judge, just appeal the judge's rulings to the D.C. Circuit Court, which, of course, the Justice Department did immediately after Judge Boasberg entered the orders.
Trump has badmouthed judges going back to his first administration and probably before that. Do you think it was the fact that Trump actually talked about impeaching the judge that led Roberts to make the statement?
Yes, I think so in this specific instance, because there have been a number of members of Congress who either have introduced impeachment resolutions or are threatening to do so, and especially in this case. And I think he wants to tamp down that if he can, because they are largely performative. They don't have 67 votes to convict in the Senate. And so they just stir people up to no good end, really, from his perspective. And I think most people who believe in separation of powers and the branches of government and checks and balances are concerned. And so I think Chief Justice wanted to get out in front of that, and I think he's made his point, and hopefully that will calm down some. And meanwhile, the case is on appeal to the D.C. Circuit, which, is what should happen.
It hasn't calmed down. One GOP congressman has filed articles of impeachment against the judge. And as you say, it's performative because none of the other articles have gone anywhere that they've filed against these judges. But, what the Chief Justice said is just plain legal practice. If you have a ruling you don't like, you appeal it. You don't try to impeach a judge.
Exactly. And historically, as Chief Justice Roberts points out, there have been a tiny number of judges. 15 have been the subject of articles of impeachment, and 8 have been convicted, but usually for, as the Constitution says, high crimes and misdemeanors, some kind of serious bodily injury to somebody or a bribe, which happens sometimes, but serious criminal behavior, not decisions with which the president or anybody else disagrees. That is not a basis for impeachment in our history.
And aren't they already appealing Judge Boasberg's order?
In fact, I think there are a couple of appeals that they've taken to the D.C. Circuit, but one was his order that the planes turn around, which is, I think, on Saturday, which he reduced to writing in the evening on Saturday, but had said clearly in oral arguments in court before that, I think in the afternoon, that that's what he expected to happen, and it didn't. And so that was a problem. But immediately after he ruled, they went to the D.C. Circuit, I think on Saturday night, with their appeal and said basically national security and executive branch power is almost absolute here, and especially immigration, and the national defense. Those kinds of arguments, which our courts have deferred to over our history, but not completely. And the judges have some role to play here, because of course the plaintiffs have argued that some of them, that they're not members of this gang, so they're innocent people perhaps among that group who are now in El Salvador.
And tell us a little about Judge Boasberg.
I think he's a highly respected judge on one of the best courts in the country, certainly at the district court level. And he had an incredibly strong reputation as a consummate prosecutor before he came on the bench. And he's been there a while, I think a dozen or more years in that court. And I think he's intimately familiar with the kinds of disputes, separation of powers, branches of government, those kinds of issues that come to the D.C. district. And I think he's very rigorous, and he's a no-nonsense judge, but I think he's very fair and enjoys enormous respect from his colleagues and from people who appear in his court.
Tell us about the questions sort of in the background here.
What led us to this point, I think, is, and looming in the background, is whether Trump is going to continue to appeal the cases, or are they going to defy court orders. They've come dangerously close to the brink in this case and some other cases, and the system can't work if that's what they're going to do. They need to appeal to the next highest court and then to the Supreme Court if they're dissatisfied with a lower court ruling at the district level, and not withhold evidence or say we're just not going to give the judge the factual matters that are important to resolving the dispute. The system won't work that way. But also there's the checks and balances, and we expect an independent judiciary not to be threatened with impeachment and other things. So all of that, I think, went into what Roberts had to say.
The vice president referred to Andrew Jackson, saying that Chief Justice has issued the order, now let him enforce it, something along those lines, which may or may not be true, but has been attributed to Jackson. So what can the courts do if Trump says, no, I won't comply with that order?
I think you're right with Jackson that it was apocryphal, but it makes for a good story. What they can do is there are tools and measures that they have. They can sanction. They can hold lawyers and litigants in civil and criminal contempt of court, and that could be impose large fines and even jail time. Judges are reluctant to use those, and they're kind of the last resort, but they can do that if there's not cooperation. Those are the major kinds of things that courts do. It's rare, it's unusual, but courts do that if they're being frustrated in their role in trying to find the facts and apply the law to the facts.
If, though, they try to a contempt citation, isn't it the U.S. Marshal Service that executes those? And suppose the Justice Department says, we're not letting the marshals do that.
Well, then I think Judge Boasberg, for example, could call the Attorney General in and have a discussion in court, because I think those people report to her, and just say, the rule of law has to be upheld, and I've ruled this way, and I expect the orders to be enforced. And I think he's determined to do that if he needs to do that, because of the relationship between the branches, judicial independence, and the need to have the information.
I don't think we've ever had a president issuing so many executive orders in such a short span of time and trying to have them executed very quickly. So you have Elon Musk going in and firing people while, they can't even make it to the courthouse doors before they're fired and out the government's door. It's hard to keep up.
Yes. I think there's a theory there which Bannon has bandied about, that they're flooding the zone. So you can't really keep up with all of the executive orders and challenge all of them immediately. And that's part of the strategy, is just to, again, flood the zone. So people are overwhelmed and thousands of people have lost their jobs. And it's important to keep your eye on exactly what is happening. And also there are real branches of government issues about Congress, the power of the purse, violating in these executive orders clear mandates that Congress has passed. Those are serious breaches of our understanding of what is appropriate by way of executive orders.
Yeah. So Trump has been calling judges names, as I mentioned, for years. You think about the judges in his cases, like Judge Juan Merchan in New York. He called him every name in the book. You know, horrible judges, unfair judges, Democrat judges, you know. Do you think that hurts the judiciary finally in the public's eye when they hear this over and over again?
Well, I think that is a concern that judges have, and I think to some extent Roberts is speaking to that. We want respect for the judiciary. We want the branches to cooperate and get along. We want them to follow the rule of law. All of those things are critical to democracy, and so they're extremely important. And right now it appears that to some extent they're being attacked or eroded, and the last thing you want is the judiciary to be considered the enemy of the citizens whom it serves. And so I think he's appropriately concerned and still is trying to be, cautious and careful about that.
Despite what the Chief Justice said, this may be just the beginning of this battle against the judiciary. Thanks so much, Carl. That's Professor Carl Tobias of the University of Richmond Law School. Coming up next on the Bloomberg Law Show, we're going to talk about the case behind Trump's call for impeachment. I'm June Grasso, and this is Bloomberg. It's a case that has turned into an extraordinary conflict between the executive and judicial branches. President Trump has invoked an 18th century law to deport hundreds of alleged Venezuelan gang members to prison in El Salvador without offering any proof, let alone a hearing. Deputy White House Chief of Staff Stephen Miller has defended the president's authority to order the deportation flights.
The president had the broadest range of authority to remove from the nation non-citizens who are part of an alien enemy force, and that's the authority the president has.
But Lee Gallant of the ACLU contends that Trump did not have the authority to use the law against a criminal gang rather than a recognized state. Federal Judge James Boasberg barred the Trump administration from carrying out deportations on Saturday. And during a court hearing on Monday, Gallant said that the administration may have violated the judge's order.
If anything, it reinforced that our view that the government may very well have violated this order, perhaps even knowingly violated.
The government contends that the weekend deportation did not violate the judge's written order, barring use of the law. Joining me is constitutional law expert David Super, a professor at Georgetown Law. David, before we get to the actual case, let's talk about Trump calling for the impeachment of Judge Boasberg and the Chief Justice in a rare statement saying that impeachment is not an appropriate response to disagreeing with the court's order. How startling is it for the Chief Justice to come out with a statement like this?
Oh, I don't think it's startling at all. The administration has been attacking judges left and right over decisions that the judges have made and has been doing everything it can to politicize the judiciary. This Chief Justice has long felt that the judiciary's role depends on it not being regarded as a partisan judiciary. So this is entirely consistent with his past approach.
Do you think it had anything to do with Donald Trump's Truth Social post calling for the impeachment of Judge Boasberg? It may be the first time in his administration that Trump has called for the impeachment of a judge.
It's the first time that I'm aware of, but he says so much that I don't follow it all. But certainly other administration officials, I believe including the vice president and Mr. Musk, have said similar things.
Let's talk about this case. First of all, what do you think about Trump's use of the Alien Enemies Act here, which has only been used 3 times, and those 3 times were during wars?
That's profoundly dishonest. The Enemy Aliens Act generally applies only in cases of declared war. It makes an exception where it can be applied without a declared war if a foreign government invades the United States. You may not like the Venezuelan immigrants that have come here because the economy collapsed down there, but that's not a government-sponsored invasion. There are no tanks, there are no cannons, there are no soldiers marching in formation. This is not an invasion. Moreover, the Alien Enemies Act provides for giving people a reasonable amount of time to wrap up their affairs before they have to leave. Again, consistent with starting a war with a country. This administration didn't do that at all. This kind of stretching the law is inevitably going to provoke a strong reaction from the courts.
So there was a hearing, an emergency hearing on Saturday, where Judge Boasberg ordered that the Venezuelans be returned to the United States. Any plane containing those folks that is going to take off or is in the air needs to be returned to the United States. Obviously, that didn't happen. So the judge held a hearing on Monday, and the government made several arguments. One, they claimed that they didn't have to halt any flights under the written order, and the oral order to turn the planes around was superseded by the written order. So basically, the oral order didn't count.
If I took that approach while I was a trial lawyer, I would have found myself in jail faster than you can wink your eye. No judge is going to tolerate the notion that their oral orders don't count. Every lawyer knows that judges' oral orders count. And when the judge did nothing, said nothing to suggest that he wasn't serious about requiring them to turn around the planes or that that was inconsistent with his order, at most the government had grounds to ask him whether he was rescinding. That's complete bad faith and will be, I'm sure, regarded similarly by the courts. Unless there be any doubt that that's bad faith, Tom Homan, the president's immigration czar, announced yesterday that they don't care what judges say. So it's very clearly they weren't misunderstanding the order. They were defying it.
The government attorney at yesterday's hearing wouldn't disclose how many planes flew or any details about them, saying he couldn't reveal key logistical details about the flights which involved classified information. So the judge gave them until noon today to provide the information that he requested. They did provide some information, but as far as the information about the planes, they just say that they departed before 7:25 p.m. His order was issued at 7:26 p.m. But they don't give the details he asked for about the specific times the flights departed and arrived.
Which is a pretty clear mark of a cover-up. If they have nothing to hide, then they should disclose that. They say it's national security, but how could it possibly be? These are flights that have long since completed. There's no danger of them being intercepted in the air. They've been on the ground for several days. This is a cover-up, and I don't think it's going to work very well.
The judge asked them several things. Are they in contempt if they didn't answer the questions that the judge asked?
If you or I behaved that way, yes, we would be in contempt and we would be reaching for our checkbooks. I think the judge is likely to bend over backwards to avoid a confrontation with the government if he possibly can, but they're giving him less and less opportunity to do that.
And the cover page was signed by all the top officials of the Justice Department. Is that supposed to be symbolic? What does that signal?
That's unusual. Ordinarily, a large organization like the Justice Department has the lawyers who are actually doing the work on the case sign the papers. I think this is the administration signaling that it regards this case as very important. And it may also be that the line attorneys feel that they're so close to the line on contempt that they want their top bosses as implicated as they are.
Now, another argument the government made is that the judge had no power to turn the planes around once they were outside U.S. airspace, that the court lost jurisdiction. And the judge did say that once they landed, he lost jurisdiction. But does the court lose jurisdiction when they're in the air?
The court has jurisdiction over the defendants in the case who are high officials responsible for the flights. The court is well within its power to order those officials to turn the planes around. If they can show that the pilots of the plane disregarded an order from the defendants in the case, they might have an argument. But there's no indication of that. These pilots would have followed orders if they'd been told to. The government chose not to follow the court's order.
Yet another argument is that federal courts don't have jurisdiction of Trump's authority under the 18th century law. The judge has no authority, they say, to question the president's proclamation that an enemy invasion has occurred, saying that it's an inherently political question.
No, it's a factual question. It's a factual question that can easily be answered. If the president were to declare that you or I is an enemy alien, that's a factual question, and courts could absolutely determine that it's not. If you say otherwise, then the president has effectively become a dictator.
So if the judge determines that those planes either took off or were in the air, it seems pretty clear they were in the air, at least, when he gave that oral order. What can he do? Is it a contempt citation?
The courts have broad authority to vindicate their powers. So he can certainly hold any individuals who are involved in defying his order in contempt of court. He can also entertain remedial orders that ordinarily a court wouldn't issue. For example, he could issue an order that any further deportation flights have to be pre-cleared by the court or by a special master appointed by the court to make sure the government doesn't try to evade the law by hurrying people out of the country the way they did on this occasion. I don't think any court would do that initially, but when the government has shown itself so capable of defying these orders and trying to defeat.
I've been talking to constitutional law expert David Super, a professor at Georgetown Law. There is another case where the government removed a Lebanese national and someone who was going to be a professor at Brown University's medical school in violation of a court order that required the government to give 48 hours notice before she was removed. The Justice Department claims that federal authorities found sympathetic photos and videos regarding Hezbollah on her phone. So that's twice in the space of a few days that the Trump administration appears to have violated judges' orders involving deportation.
Yes, and I think it's not surprising that these most blatant violations involve deportation because the very act of violating the order makes it almost impossible for the court to correct anything. But the administration's repeatedly deporting people contrary to court orders is likely to lead to more intrusive court orders. Courts try to defer to the executive branch on the assumption that it is always trying to follow the law, but when the administration shows that even court orders don't faze it, it can expect more intrusive court orders and will have no one to blame but itself.
Even at this hearing, the ACLU lawyer said that we're close to a crisis, a constitutional crisis. In a battle between the power of the executive branch and the power of the judicial branch, so if Trump just chooses to start ignoring court orders, what can the judicial branch do?
They can do a great deal. They have sweeping powers to hold officials in civil contempt, which means that they can apply coercive measures against those individuals until they come into compliance with the court order. So if, for example, they find the administration is running deportation flight contrary to court orders, it can enter an order against the officials in charge of those flights that they will lose $1,000, $10,000 a day out of their personal funds until they come into compliance with the court order. And the court can simply send their banks an order compelling the money to be passed over. The administration may violate court orders, but I don't think banks will.
We're just about 2 months into the administration, and Trump has said, I always obey court orders. But does it seem as if we're coming close to the point where that's not going to be true anymore?
Well, it's not true now. They were ordered to lift their freeze on federal funding early in the administration, and they've continued and even expanded those freezes. They were ordered to restore the projects that they illegally terminated at the U.S. Agency for International Development, And at last report, those programs continue to be frozen. The president and his administration are not complying with court orders, and whatever he's saying is either misinformed or untrue.
He seems to think that the Supreme Court is his answer. You know, they're at the Supreme Court for the third time in, as I said, about 2 months. Do you think this court, I mean, judging from what Roberts said today, perhaps some of them are fed up enough to, ignore Trump's requests?
I think the Supreme Court is philosophically sympathetic with a number of things that the administration wants to do, and they do believe that the president leads the country. But they don't believe that judges themselves or others are irrelevant, and they believe the way to resolve legal questions is to litigate cases in court and appeal if necessary. So I don't think they will support the administration disregarding court orders. The Warren Court was very sympathetic to civil rights protesters, but when they defied a blatantly unconstitutional order against protesting, the Supreme Court in Walker versus City of Birmingham upheld the contempt citations and said that no matter how bad a court order is, you have to follow it until you can persuade a higher court to vacate it.
Just to be clear, do you think that this judge will say you're in contempt of court at some point if he sees that the times of the flight don't match, what he was told?
I mean, he has two tasks. First, to determine if contempt of court occurred, and second, if it did, to determine who was responsible. I believe from the orders that we've seen and what he said in court that at the moment he's working on the first of those. If he determines that the administration did violate his orders, then he's going to ask who conveyed what information to whom at which time so that he can determine who might have violated it. I would expect that before he finds anyone in contempt, he would ask them to come to court and answer questions about what they've done and give them an opportunity to explain themselves.
I mean, so many people are being swept up in these quick deportations. You can even be sure that the Venezuelans that were shipped there were members of the gang. I mean, there might have some innocent Venezuelans in there, too.
Or Colombians or Panamanians. In the sweeps after the 9/11 attacks, they rounded up a lot of people who were brown, some of whom turned out to be not Muslims or Arabs, but Mexicans and Salvadorians.
And is it legal for him to pay another country to have immigrants housed in prisons there?
If he has an appropriation that could fairly cover that, some of the administrative appropriations for federal agencies have a certain amount of flexibility in them, so I'm guessing he probably could find $6 million somewhere. One other thought that's worth considering here, the Biden administration's actions were overturned repeatedly by the Supreme Court because the court said that while the law might technically support what the administration was doing, their so-called major questions doctrine made it implausible that Congress intended to allow something as sweeping as what Biden did on the eviction moratorium, on environmental policy, and on student loan forgiveness. The administration's actions under the Enemy Aliens Act is a classic example of that. A narrow statute enacted for wartime is now being treated as general immigration law. The major questions doctrine that this administration has celebrated is likely to come back and bite them.
Thanks so much for joining me tonight, David. I always appreciate getting your insights. That's constitutional law expert David Super, a professor at Georgetown Law. Judge Boasberg has ordered the government lawyers to submit a sealed submission by Wednesday at noon, and his questions relate to the 2 flights that left before 7:25 p.m. on March 15th. He asked, what time did the plane take off from U.S. soil and from where? What time did it leave U.S. airspace? What time did it land in which foreign country, including if it made more than one stop? What time were individuals subject solely to the proclamation transferred out of U.S. custody? How many people were aboard solely on the basis of the proclamation? So this court battle continues tomorrow. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.